Excuse me, we'll call a case of Michael Martin versus Milham Meadows Limited. Please proceed.
Good morning. May it please the court. My name is Robert Kamenek. I represent the defendant appellants in the case. Your Honor, I'd like to reserve 3 minutes for rebuttal, if I may. And I would waive the no fire zone rule at the discretion of the court. This court issued an order asking whether or not there exists genuine issue material facts with respect to the facts of this case under a specific statute, which is MCL 554.139. As the court knows, this is a case that deals with stairs and deals with, in our view, the proper interpretation and application of the statute. The statute has two parts. The first part deals with whether or not, through a covenant, the premises are, in the present tense, are fit for the purposes intended. I'll address that first, and I'll address the reasonable repair second, because the Court of Appeals found a question of fact on both prongs. On the first prong, the case law from this court, as a matter of fact, the only case law I could find from this court is the Allison case. And in Allison, in Chief Justice Markman's opinion, it was pretty clear that the notion of fit for the use intended is something a little bit different than what you'd normally see in a tort case, which deals more with a risk of unreasonable harm. With respect to stairs, it's a matter of whether or not there's reasonable access to the different levels of the building. I think that's pretty straightforward. I also think the Court of Appeals
Counsel, good morning. Happy New Year. Welcome. Fit for
good morning, Your Honor.
Good morning. I guess the question I would pose to you is that what is the ultimate purpose of a staircase? Is a stair there for decor, or a stair is for travel, is it not?
Well, Your Honor, it's a good question, but under the case law from this court, the purpose of the stair is to go from the stairs, and the question is to go from one level of the building to another. And in this case, it's from the first floor to the basement, where all the gymnastic workout equipment was. And it's within that context, and I'm glad you asked that question, that you have to interpret the statute. I would suggest to see whether or not the stairs are fit for the use intended. If the intent is to allow a person to go from one level to the other, and there's reasonable access, then indeed the stairs are fit for the purpose intended.
But if the stair is dangerous, if the stair is slippery, if the stair isn't created for its ultimate intent, doesn't that kind of pose a problem in the sense that if the stair can't be accessed or used or traversed in the way in which it was intended, doesn't that ultimately render it difficult or dangerous to travel between one level to another?
Your Honor, it's a matter of degree. The case law from this court says that with respect to the first part of the statute, we're not talking about an ideal condition. We're not talking about the most accessible condition possible. It's a matter of whether or not it's possible in the sense that you can actually navigate from one level to the other. That doesn't require perfect premises or the like. And
Should
again,
we think about whether the stairs allow for safe access?
Sure they do. I'm sorry, Your Honor, is that a question or statement?
Question, should we think about safety when we're thinking about reasonable access? Is safety important?
Safety is important, but the covenant made in under this contractual statute is simply that you have reasonable access from one level of the building to another.
So safety is not a component?
Safety is it's a matter of degree, Your Honor. So perhaps I can...
Reasonable safety, maybe?
Well, but at the same time, when we get to reasonable, we start getting into a tort standard. And so reasonable access, yes.
We're just trying to figure out what reasonable access means.
Agreed, but I would suggest you hear what reasonable access means is you can use the stairs on multiple occasions without incident. You look at the dissent in the Court of Appeals case in Hayden, and there's not a lot of cases out there on this, but on Hayden, the Court of Appeals in that case found it was insufficient that somebody had traversed the icy stairwell 3 times. Judge Meadows dissented on that and found that was sufficient. Here, We can talk about how to define it, but the bottom line is that we all know that these stairs have been traversed many times, hundreds of times without incident. So,
But there you're going from the standard now to the application of the standard, right? You're telling us the questions there, but what's the broader standard? Do we consider?
the standard under the existing case law is reasonable access. Get back to Justice McCormick's comment.
And you agree that safety is a consideration?
It's a consideration, yes. Safety is, insofar as safety is a consideration, in these facts, it's satisfied.
So you would agree if the plaintiff had evidence establishing that the stairs did not allow for safe access to the lower level, that they would have met their burden at this point?
No, I think the plaintiffs have to demonstrate there's not reasonable access. Safety isn't the only aspect of reasonable access.
So if there's access but it's not safe, if you, instead of stairs, if they shoot the person out of a cannon?
Well, sure. I mean, for example, Your Honor, if there were 2 risers missing from the stairs, stairwell of 9, and you had a particular plaintiff that said, I've traversed these 10 times because I know there's a defect there, quote defect there, and I've been able to have access, I would not necessarily call that reasonable access. Because you have something innate with the stairs, you're missing 2 of the risers.
Right, so you agree that safety is part of it. It's like you couldn't, if the staircase went through a shark tank, but we had a really good swimmer who every single time she went up and down, she was able to avoid the sharks, you wouldn't say that was reasonable access. You would say that's unreasonable access. So safety is some part of it. You just think in this particular case, in the application, this is a silly case.
Your Honor, it's a vivid example, which I like. But yes, I would
There's
agree
always
with
a
you
shark tank in my hypotheticals. Just get used to it. Always a shark tank.
It always works. And maybe it'll even be an opinion. You never know.
I'll try.
I don't know if I've answered your question, but I'm trying to compare the 2 situations in that regard. There's nothing innately wrong with these stairs in that sense. There's not a fundamental...
We're talking past each other just in the sense that I'm trying to look at the general rule that might emerge from a case like this, and you're focusing on the specific facts. You agree, it seems to me, that theoretically there's a possibility that stairs would be maintained in such a way that they would not be fit for their intended use because they wouldn't allow for reasonable and safe access. They would either go through a shark tank or they would have, an oil slick on them or some other condition that would make them very dangerous.
Sure, Your Honor. I mean,
you're just saying that you don't believe that's the case here.
Correct. Your more traditional defect would be that way. For example, let's assume that the stair is such that your foot would actually go through it. One, safety is a measure. 2, you don't have reasonable access in those circumstances because you have to basically dodge that sort of condition where it really inhibits you altogether from using the stairs.
Let me see if I can bring some context to this.
Sure.
The statute requires that the stairway be fit for its intended use of going from one level to the other.
Yes.
The statute doesn't require that the stairs be in the safest possible condition conceivable.
Correct.
How do we draw the line as to where there's a cutoff? That's the challenge in this case, isn't it?
Agreed. And I would suggest to the court it probably deals, I did not see this in the case law, but it probably deals with whether or not the stairs still have utility value in that regard, and you can take advantage of the utility value. Can you get from one level to the other, because that's what the stairs are intended to do. That's what the lessor promised by way of the covenant in the lease. Again, I have not seen the case law that necessarily talks about being able to use the condition or the premises that you can use the utility of it, but I think that's baked into the notion of reasonable access.
So let's look at reasonable repair then.
Yes.
And I always like to look at things in a pragmatic, straightforward manner. And the judge in the lower court said that the plaintiff should have been, which I thought was an unusual statement from a trial court judge, that he said that the plaintiff should have been banging on the drums. And I guess my question is, in this situation, when we talk about the issue of reasonable repair, what should the plaintiff have done differently in this situation?
Well, reasonable repair should be interpreted with respect to the first part of the statute. What does it take to return the stairs, in this case, to the condition that they are fit for the purpose intended?
But I think we can't overlook, and I think it is important to note, that this was a significant injury. I mean, this was catastrophic. This person is requiring attendant care 24/7. So this person got horribly injured. This isn't like a simple slip and fall. This person's life has been changed forever. And I say that because aren't we kind of going in a circle where we talk about what is the purpose of a stairway? Isn't the sense of a stairway, if you're talking about reasonableness of repair, and I'm a renter in an apartment, and isn't the purpose of a stairway to be able to access it safely? I get we've been going back and forth about the reasonableness of it and how safe can it be, but if a stairway is inherently dangerous, as is alleged in this situation, how do you address the reasonableness of repair? If I'm living in this apartment and the stairway has a defect that makes it slippery, which resulted in a catastrophic injury, how am I able to utilize that device, which in this situation is the staircase?
Well, a couple observations, Your Honor, if I may. First, the severity of the injury really, in my view, is not material to the proper interpretation of the statute. I understand the notion, but again, we're talking about interpreting a statute, and we're not talking about a tort case. We're talking about a contract case. Secondly, I don't think there's been any claim, and perhaps I'll stand corrected, that the stairs were inherently dangerous. Matter of fact, the Court of Appeals found, as you might recall, that the open and obvious doctrine wasn't applicable here.
Right.
And so
They were slippery. I mean, we're focusing on the issue that the stairway was slippery.
And perhaps it's difficult to carve out a rule here, and I acknowledge that. But again, the court order was whether or not there's a genuine issue of material fact here. And if you take a look at the worn stairs, which really is the only claim that's available to the plaintiff, anything, I'll come right back to this point, but anything to do with adding something more to the stairs that they originally had does not fall within the purview of the statute. That talks about an improvement above and beyond putting the stairs in a condition where they're fit for the purpose intended. So there's no evidence in the record that the paint that was originally used on the stairs was anti-skid. There's no evidence that there were anti-skid strips. There were no evidence that there should have been rubber. There were rubber linings, so to speak, around the nose of the stairs, of the rebutting part of the risers. So here we're just talking about pure whether or not it's slippery. And I have to keep coming back to the notion that let's assume that the stairs are worn and they're slippery. I keep going back to what the statute says and the facts of our case as well. Thank you.
2 minutes.
2 minutes left for
your time.
Altogether? I'll finish my sentence and then I'll reserve the rest for rebuttal. With respect to this incident, we do know that at least twice before the day in question, the plaintiff had no problem traversing the steps. We know the week before it was at least 12 times. We know that the month before it was 60 times. No difficulty at all. So all I'm suggesting to the court, and here's my final comment, these stairs were already in reasonable repair because they were fit for the purpose intended. Really, whether or not they're in reasonable repair is not a genuine issue of material fact because they're already there.
Thank you.
And I'd ask the court to reverse.
Good morning, Justices. Joseph Sukup on behalf of Michael Martin, co-counsel Aaron Wisely at the table. Your Honors, the answer to your question that you've asked us to respond to is an unequivocal yes. There are a multitude of material questions of fact that need to be decided by the trier of fact in this case. This court follows the rule of 7.305 in order to determine whether there's a basis to take up a claim on review. The two bases to allow such a claim to be reviewed by this court is whether the ruling of the Court of Appeals is clearly erroneous, which we submit is absolutely not the case. Their ruling was very clear and specific regarding each of the areas of general issues of material fact. And secondly, the ruling by the Court of Appeals in this case took into consideration the ruling of this court in Allison and this court's denial of Haddon that works with a question or dealt with a question of fact of ice in a common area on a staircase in a rental apartment. This court decided in Haddon to deny leave in that case and let the Court of Appeals do what it's intended to do to determine if there is a question of fact. This is not the case like in Lowry where this court decided, wait a minute, the Court of Appeals shifted the burden and put some onus on the defendants to prove that they did not have actual knowledge. That is not what happened in the case here in the Court of Appeals, Your Honors. The Court of Appeals looked at each of the questions of fact that the trial judge ignored. And as Judge Bernstein pointed out, beating the drums. One of the conclusions that this court has reached in looking at cases such as this is, A, did the defendant have knowledge of it? Did they have actual knowledge? Did they have constructive knowledge? For what period of time did they know? My client continually, over the couple of years that he lived there, continually complained to the one maintenance person that they had for this 300-unit Section 8 complex. Then he took the instruction of the maintenance man and says, look, I can't help you, so go write a letter. So he goes, writes a letter. My client is in this subsidized housing because of the disability that he has. And just as the Court of Appeals pointed out, what else is he supposed to do? I tell them repeatedly that I'm slipping, and contrary to the multitude of briefs that this court has received by defense counsels, it isn't that he was able to traverse these steps without incident. He was slipping on multiple occasions, as was his son, and as were other visitors coming. And he brought that defective condition to the attention of the landlord and the defendants in this case. And, Your Honors, they did absolutely nothing. An argument that's replete in the briefs filed by the defense is, and the ruling by Judge Lipsey, was that, well, you can't expect the landlord to repeatedly go back to find out what's going on. My client isn't asking that. We're just asking the landlord to, would you please respond to my pleas for help because I keep slipping. And yes, he slipped on his tailbone and all the other times that he traversed these steps, admittedly on multiple occasions, Your Honors, without incident, because he was an athlete, possibly. But again, it doesn't matter. As this court has pointed out repeatedly, negative evidence is not sufficient to justify a motion, the granting of a motion for summary disposition.
Counsel, let me
yes, Your Honor.
Let me just ask a structural question. I mean, whether negative evidence is admissible is one question. We just have to determine whether there's a question of fact as to a breach. Is that correct? Is that fair to say?
Yes, because that's all the Court of Appeals did, was decide that there is a question of fact. And
we have a contract case here, not a tort case, right? And the duty is defined in the statute, right? The statute requires that the landlord do certain things with respect to this apartment, correct?
That is correct, Your Honor.
So now for us, we have to decide, is there any question with respect to whether that duty, that statutory duty that's given here, was breached? Is that a fair understanding of what we have to do?
As the status of the case as it presently is, that is correct, Your Honor.
And you would agree with me, would you not, that not in your case, I understand your position here, but it's not impossible for a court to say that there is no question of fact as to a breach. A court can decide that as a matter of law, couldn't it?
Conceivably.
Conceivably. That's all I'm asking. Just
Certainly,
conceivably,
yes.
You could decide as a matter of law, there's no question. You could imagine a case where there really was no dispute about a breach. Is that fair to say?
I could certainly, Your
Do you
Honor.
think that's what the trial judge did in this case?
No.
Okay. Why not?
The trial judge completely ignored all the proffered evidence that had been submitted by the plaintiff.
Okay.
And totally ignored the rules of this honorable court when it was supposed to take all the facts proffered in favor of the non-moving party, Michael Martin. He completely ignored them.
But however sloppily, do you think the trial judge intended to say, I don't believe there's a question of fact as to breach in this case? I mean, he perhaps could have done so more articulately or more clearly, or I'm just trying to understand if you think that's what I'm trying to make sense of. I'm trying to put it together. Is that, I mean, effectively, that's how this case would need to be dismissed, I believe. Given that there's no question about duty, we know what the duty is, so is that what you think the trial judge was trying to do?
With all due respect, and no disrespect to Judge Lipsey, because I'm the one that argued the motion, both defense counsel and I were perplexed because we didn't know what his decision was. So I cannot respond to that,
Fair
Your
enough.
Honor.
Fair answer. Yeah.
The questions of fact that are delineated very specifically, not only in the arguments that I've previously presented in the SD motion and before the Court of Appeals, in this Court's review of the Court of Appeals' opinion to determine whether or not the Court of Appeals' decision was clearly erroneous, there is no basis. They clearly followed this Court's instructions, this Court's prior decisions, and applied them to the facts and the circumstances of this case. And all they did was find that there was a question of fact for the jury to decide whether parts A and B of this statute were violated. And as the final prong of this, or section of this statute, the legislature made it very clear that the statute was intended to protect, take care of, and consider, not beyond consider, but protect the citizenry of those tenants that are under the control, for lack of a better word, of a landlord that controls their premises. And the statute is to be construed liberally. And all the Court of Appeals did was say, you know what? I believe Mr. Martin has proffered more than sufficient evidence to create questions of fact as to each element of the claim that we've brought. And I submit to this Court that because the Court of Appeals did not commit any clearly erroneous error, and because the only thing they did, as they did in Haddon, was to say, you know what, there's a question of fact. There's nothing for the Supreme Court to decide. And I submit to Your Honor, your Justices, that there is no basis to grant leave. To grant leave in this case would essentially open the floodgates to every time the Court of Appeals makes a ruling on an SD motion where it does not alter this Court's decisions and this Court's rules, would just open the floodgates to endless pleas for application to leave. I submit to this Court that there are multiple. Yes, Your Honor.
It's your position that it wasn't fit for its intended use.
Absolutely.
And it's your position that it wasn't in reasonable repair.
Absolutely.
Yet your expert acknowledged that the slipperiness of the steps depends on the shoe, depends on the speed, depends on the size of the step, depends on the coefficient of friction on the stairs, and the coefficient of friction is a function of the shoe and that the person who's wearing it. And yet he acknowledged that he didn't have any knowledge as to these conditions. How does that make it unfit? If we don't even, if he doesn't even know these factors, how is it that he can conclude that the stairs are unfit?
Just for clarification, Your Honor, the he with whom you're referring is my client?
No, expert, plaintiff's expert. It might be she. I don't know. Glon.
No, it is a he, Glon. Glon went in and measured the steps and found that each of them were not of the same dimension as the Boca Code requires. He found that the condition of the steps, as I pointed out in the brief, when he had finally had the opportunity to inspect the steps, were already repainted, which is another issue in and of itself. But relative to the fact, and the foot that's in the photograph attached to the motion is my foot, and half of it's hanging over. That shows the dimensions. What Glon opined, both at his deposition and in the report, Your Honor, is that the steps are of a short depth that would not allow an adult foot to be on it, coupled with the fact that the nose of the steps on most of these steps are worn down, and the shiny paint that they have been that were used to paint over these steps had been worn away over the past several years, and that taking into consideration, Your Honor, and as just a brief aside, as I was walking into Your Honor's court here today, I noticed the steps as I was coming up, as they had the demarcations and the tread, which is for traction purposes, and as Glenn pointed out in his report, the ability for the lay person to see the difference between one step and another. And as Glenn pointed out in his report, one of the safety factors is that when you paint these steps in this gray paint, essentially the brain can interpret it as just all one space, and the average person doesn't necessarily see where one step ends and the other one begins, contrary to what I walked up today. My point is there a question of fact as to taking all of those factors? The jury could look at his report, listen to his testimony, and decide, well, wait a minute, one or more of these things could have come together to cause him to keep slipping. It isn't just the one occasion, Your Honor. It's not the fact that he slipped, tripped, however one considers it. His foot goes down, and it isn't the only time, and I want to emphasize that. He's continually slipping on these steps, Your Honor.
Okay, thank you.
Thank you. And for those reasons, I ask this honorable court to decline defendant's request for application of leave, allow my client to go to trial and have these issues heard by the trier of fact. Thank you very much, Your Honor.
Your Honor, I know I have limited time, so let me make a couple of points as quickly as I can. First, there are errors in the Court of Appeals opinion. That's part of why we're here. So as I mentioned earlier, when the Court of Appeals looked to see whether or not the premises were fit for the purposes intended, they looked at measures in the expert's report that were never included on the original stairs. And there's no evidence that they ever were included. So the notion here is that to put these stairs back into a state that they're fit is such that you have to go above and beyond their original condition. And that's error. And that's the first error the Court of Appeals made. And that's one of the reasons I think we're here. The second error is that, and I quote page 10 of the Court of Appeals opinion, this is my last point. They said, the court said the ability to avoid the condition in and of itself does not show that the premises are fit. In some circumstances, maybe. And that's when I talked about Hayden, where the stairs had been encountered 3 times. Here we're talking about stairs that have been encountered 1,800 times without incident.
Counsel, what should, and I like to ask questions like this because I'm thinking of things in a very big picture in terms of how it affects people and the statute and how the law intertwines. What should the plaintiff have done differently in this situation? What should he have done differently to avoid this catastrophic injury? What should he have done differently from what had happened?
Your Honor, the Court of Appeals has already ruled that there's no cross appeal that was open and obvious. You have a ruling by way of law in this case that the plaintiff could have observed the condition upon casual inspection. The plaintiff could have avoided the condition at that point in time. That is.
But I guess my question is,
I'm sorry, Your Honor.
no, of course, no, you're doing fine. I guess my question would be if you basically if you're living in this unit, and you're in this building, and you lodge complaint after complaint after complaint, as we allegedly heard, what is it? Do you see the concern that somebody would have that would arise out of this? What is a tenant supposed to do in this situation? You basically, you're in a circumstance, you complain about it, you've had near misses a few times, you let the building know, they choose not to act, and what more is a person supposed to do if they're put into this situation?
Well, Your Honor, I have to assume the facts most favorable to the plaintiff. That's the standard of care or the standard of review at this point in time. And the only answer I can give you is they are to avoid the condition.
I'm sorry?
They are to avoid the condition. If it's open, obvious, it's evident upon casual inspection, you avoid it.
But doesn't
Right.
that mean then that there wasn't reasonable access?
No, because, here, there were different ways to go up and down the stairs, and also the plaintiff had never had a problem with this particular stair, the top stair, on 1,800 occasions.
So I guess, doesn't that create a paradox?
I'd suggest not in the facts of this case, Your Honor.
He can't, you're saying he should avoid it just sounds to me like you're arguing two contrary concepts.
Well, all I'm arguing is that the plaintiff had successfully traversed the stairs on 1,800 occasions, and at least 60 occasions a month before the date of the accident. I think it's self-evident that the plaintiff had the ability to use the stairs to go from one level to the next and had reasonable access thereof. If we're talking about a situation where, again, you have a condition whereby it simply cannot be avoided altogether, as I mentioned before, two of the risers are simply missing, that's a whole different story. But here, and I'm not trying to be trite, but here the proof is in the pudding.
Thanks.
Thank you. Case
Your
will be
Honor.
submitted.